So, if it was plausible, at least when announced, if it was generally accepted, and if I can work with it as a judge, which is to say as a lawyer, then I'll accept it. If, on the other hand, let's take a fanciful case, Roe versus Wade, if there was no basis for it at the beginning, even those who liked the result acknowledged that the opinion was...
Judge Bork once said that, famously said, it contains not a single sentence of legal reasoning.
It's a bad opinion. It was controversial from the outset and remains so. But thirdly, and most importantly, it does not permit me to function as a lawyer. Roe versus...
That is the what do you mean by that?
Roe versus Wade in its new incarnation, which is a case called Casey.
Yes.
Casey, in fact, while saying we will never overrule Roe, overruled Roe. It threw out the trimester system, and the new test of unconstitutionality is whether the state law in question places an undue burden on the woman's right to abortion. All right, that comes before me as a judge. How am I supposed to answer that question? Being a lawyer, I would normally run to the law books and see,
what's an undue burden?
For 2 centuries, no burden was an undue burden. You could prohibit it entirely. So what do you think? How do you think we're going to decide the next case that comes up? Let's say a state law that requires a certain staffing of abortion facilities, so many nurses, so many doctors, expensive equipment, all of which raises the price of abortion. Okay, the claim is this places an undue burden. What do you think we're going to talk about? I guarantee it'll be, doctors, nurses. I don't think that's an undue. You think it's an undue burden? How many think it's an undue burden? It's 5 hands it is, 4 hands it isn't. It's not law. I will not do that. So, by and large, I accept past mistakes, but not those that cast me in the role of... And somebody has to make that call. I don't mean to minimize the importance of somebody making that call, but it's not a lawyer, it's not a judge. It's a legislature that makes those calls.
You think there ought to be a right to abortion? No problem. The Constitution says nothing about it. Create it the way most rights are created in a democratic society. Pass a law. And that law, unlike a constitutional right to abortion created by a court, can compromise. It can see... Oh, I was going to say it can split the baby. I should not use...
Why are judges experts on these questions? What did I learn at Harvard Law School that gives me any more insight into whether there ought to be a right to assisted suicide, or whether there ought to be a right to homosexual sodomy, or whether there ought to be a right to abortion? Any more insight than Joe Sixpack? Why do we think we give these questions to judges? It absolutely befuddles me. The judges have no special qualification for this. They get it only because they're operating under very vague, generalized treaties that I guess they could say they're forced into it. But they're no experts on that subject. Now, I believe in natural law, but I believe that in democratic political institutions, It's up to the people to decide what they think natural law demands. So you have political campaigns in which people say women have a natural right to abortion. Fine. Say that in a political campaign and then put it to a vote. Because we all disagree on natural law. Why say whatever a bunch of judges think is the answer? That makes no sense in a democracy. There are no clear judicial answers to these questions. And since there aren't, it seems to me it's the kind of a thing that in a democracy we debate with one another. And we ask the people, what do you think the natural law requires? That is how I think natural law comes into play in the political realm.